Okie dokie, artichokes. I think we are ready to rock and roll. Good morning. Welcome to New Jersey Green Horizons, Navigating the Cannabis Legal Landscape, brought to you by NJM Insurance Group, NJBIA HR Support Center, Focus New Jersey, Davison Eastman Muñoz Paone, NJ Business Magazine, and Association Member Trust. I'm Casey Skarecki, Sponsorship Sales for the New Jersey Business and Industry Association. With us today are labor and employment law attorneys Brian Chabarek, partner, and Nicole Croddick, she, her, of counsel from Davison Eastman Muñoz and Paone. Today's webinar is also being recorded and will be emailed to you tomorrow, so be on the lookout. I'd also like to draw your attention to the questions tab. We'd be happy to take your questions at the end, so get them in as they come to you via the questions chat box. So now, without further ado, Brian and Nicole, we are thrilled to have you here, so take us away.
Thank you.
Thank you. So as we alluded to, we're going to focus on cannabis law in the employment setting. In 2021, the New Jersey Cannabis Regulatory Enforcement Assistance and Marketplace Modernization Act, also known as CREMA, was enacted. That established a legal framework for the legalization of recreational cannabis. The statutory provision set forth the framework for licensing, regulations of facilities, but it also has provisions in there concerning employment, which has left a lot of open-ended issues for employers to deal with since its enactment. Back in 2010, medicinal marijuana was legalized in the state of New Jersey. In 2019, the Jake Honig Compassionate Use Medical Cannabis Act was enacted, which significantly expanded the medical cannabis program in the state of New Jersey and created the Cannabis Regulatory Commission, which is charged for enforcement of both the medicinal program and now CREMA. Next slide, please. As you know, the legalization of marijuana has been a topic for several decades. And as you can see from the slide, which I believe is from the 1950s or 60s, it's been talked about, but eventually the voters in the state of New Jersey did approve its legalization for recreational use, which is what established CREMA in February of 2021. Next slide.
So just to give a little primer to start out with, just because I think this is interesting and a lot of people don't know this, the term cannabis, I like to think of as a legal term of art. It refers to any marijuana that's purchased from a licensed cannabis business, like something like a dispensary, and it is legalized in this state. Marijuana, on the other hand, is, marijuana, but also cannabis that's purchased outside of the regulated market, which is not legal in New Jersey, but is decriminalized. And once we had the legalization, as per what Brian just said, we did, as far as our state was concerned, there was a new regulated industry for anyone to buy cannabis in these dispensaries. And all of this, the sales were overseen by as Brian mentioned, the Cannabis Regulatory Commission, the CRC. And of course, though similar to alcohol, which there's a lot of analogies that we're going to go over with alcohol and cannabis, you have to be 21 years or older to buy cannabis from the dispensary. And of course the CRC is implementing and still working on this rules for the marketplace as far as licensing, product safety, revenues, and various requirements. And just to mention too, just because there tends to be confusion between cannabis and marijuana, THC is the element the element in cannabis that actually makes people high or impaired, whereas CBD is another element within cannabis that is something that is, does not really have that sort of effect on someone as far as making them high. And that's why you might see CBD products being sold at, CVS or in the mall or in the grocery store. When it comes to marijuana, whether it be for medical uses or recreational uses, remember this is considered legalized in the state of New Jersey, meaning cannabis. However, on the federal level, it still is a controlled substance that's prohibited. So In addition to that, if you look at the federal law, the Department of Transportation's drug and alcohol testing regulation, that of course relates to anyone that is, working under the auspices of the Department of Transportation and driving, trains, buses, etc., trucks. It doesn't authorize medical marijuana under a state law to be a valid medical explanation for a transportation employee's positive drug test results, which again, you'll see foils what is going on in New Jersey. Therefore, if this happens, the medical review officers will not verify a drug test as negative based upon the information that a doctor recommended that this employee use medical marijuana for, cancer, epilepsy, whatever it is. Because as I mentioned, marijuana on the federal level still is a Schedule 1 prohibited controlled substance under the Controlled Substances Act, and therefore is not acceptable if someone, again, is subject to drug testing and we're looking at it from a federal standpoint. Billions of dollars are lost each year. The statistic, according to the National Drug Intelligence Center, says over $100 billion a year lost in productivity due to substance abuse. And worse than obviously that pretty staggering financial impact is the personal impact that substance abuse has on your employees, not only the people subject to it, but the people that are managing them and working with them. The good news is we're going to talk a little bit about reasonable suspicion testing, and supervisors and managers and HR professionals that are trained in detecting reasonable suspicion of impairment are at least another mechanism that we can use to decrease the chances of productivity loss, thereby ensuring workplace safety, which again, under occupational safety and health laws, everyone does have the right to work in a safe work environment. So when it comes to reasonable suspicion testing, here's some of the tools that you should be mindful of to manage these situations. Unfortunately, none of this is an exact science, but this is the best that we have. When you're implementing pre-employment drug screening and random drug testing, remember, they go a long way to hopefully endeavor to have that drug-free workplace. But you're still probably going to, at some point, especially now, have to confront someone on the job that is impaired or likely impaired by drugs or alcohol. And how you handle it is going to be very determinative of the overall health and safety of the whole workplace, as well as whether or not you're subjecting yourself to legal risk. So hopefully the takeaway is now and at the end of this presentation that you'll be very familiar with the policies that are in place in your organization, and of course the evolving law at the federal and state level, and of course what reasonable suspicion testing would entail. So the benefits of drug and alcohol testing, or any testing when it comes to impairment, is that, as I mentioned, it improves morale and productivity while decreasing situations like high levels of absenteeism, accidents, downtime, turnover, and theft. And when your business conducts the fair and consistent reasonable suspicion drug testing, you are sending a message that, and also hopefully dissuading and detecting drug and alcohol use that is affecting the workplace. So the whole point is to empower your supervisors to know what they're looking for and what to do if they suspect, and remember, it's suspicion, not certainty, drug or alcohol use, to endeavor to have that safe workplace. Reasonable suspicion testing is also called for cause or probable cause testing, and it's something that is put in place when an employer has a strong reason to believe that an employee might be acting under the influence, i.e. might be impaired, on drugs or alcohol on the job. And, like I said, a couple points with this, it's not absolute certainty. That's what the second prong is for. If you suspect this, you send them for testing, which we're going to go over. But also, we're talking about drugs or alcohol. And I always say you're not allowed to be impaired at work, whether it be on marijuana, heroin, or even large amounts of Benadryl or something like that, or, alcohol. So it's all really a similar analysis. So reasonable suspicion or for cause or probable cause testing happens when one or more, we always recommend obviously at least two, trained supervisors believes that an employee is under the influence of alcohol or any legal or illegal controlled substances, including, prescription medication, illicit drugs, marijuana, and as I said, even, maybe Benadryl or something like that. And this reasonable suspicion is based on, I always say, articulable, personal observations, which can include the display of physical signs, like if someone's staggering or falling over, psychological signs, like maybe they seem to be angry or irrational, or behavioral signs, such as, maybe the person is just, walking around burping or, things like that, that might lead you to believe that they're impaired. And the signs have to be articulable and documentable. And I always say, of course, it's important to have them be, observations that are made at that moment. Observations that you saw yesterday and acted upon today are no good. They're not contemporaneous. And why do we care about reasonable suspicion testing? It could be that useful tool that we're looking for in addressing perceived impairment or drug and alcohol policy violations that are, again, coming out of your handbook. So if an employee seems impaired or is suspected of violating the drug and alcohol policies that are in place in your organization, a request for a test, a drug test or an alcohol test, is a reasonable means to gather additional information as you formulate a response. So I always say, if people are adamant, like, I don't want to get the test, I have nothing to hide, I always say, well, the test will obviously show that. So as I mentioned, that's going to be a next piece in the puzzle that'll give us additional information, and then we can, move on to what the next step is. And as I mentioned earlier, reasonable suspicion testing is not, certainty is not required. Okay, just that reasonable suspicion. So some of the documentable facts that would be very important for those people, the managers that are making these contemporaneous observations, to include are very common sense, if you ask me, but facts that might lead you to think that someone is, under the influence or impaired. And they would include, odors, like, does someone smell like alcohol or marijuana? What about body odor or the smell of urine, or unusual or erratic behaviors? Movements that might include walking or acting in an unsteady way, fidgeting, being dizzy. Also looking at someone's eyes. Are they red? Are they twitching? Are they dilated? Are they watery or constricted? Also observing someone's face. Is it flushed? Are they sweating? Do they look confused? Do they have a blank look? Speech. Is the speech slurred, slow, distracted? Are they unable to verbalize thoughts? Emotions. Does someone appear irritable, drowsy, agitated, argumentative? Of course, actions like yawning or twitching, and inactions like sleeping, unconscious, or when someone has no reaction to questions. I did have a client recently that told me that when it came to this, they saw someone actually keel over at their desk. So they said, is that good enough? And I said, you and someone else write that down. I'm pretty sure that that's a good, coupled with some other factors, that's a good reason to send them for reasonable suspicion testing. So when it comes to another aspect of the marijuana industry and the cannabis industry in the state of New Jersey, I do want to mention a little bit about police involvement. And this is more, from a criminal law level, just to give you a little background. So interestingly enough, law enforcement cannot use the odor of marijuana or cannabis alone as a reason to conduct a stop or search of a person to determine if they have possession of any amount or distribution of 1 ounce or less, unless there's a couple exceptions. You're on school property or at a school function or in some sort of detention facility. Additionally, police cannot search, arrest, or detain someone simply for possessing any amount of 1 ounce or less of marijuana or cannabis. Law enforcement also, and this has been a recent change, recently amended, are now permitted, however, to provide a written warning to individuals that are ages 18 years to 21, and must provide the written notification to a parent or guardian for those under the age of 18 who are found to possess or consume any amount of marijuana. And remember, the rule that legalizes this says you have to be 21 or older. So that's a little background on that. Also, you cannot be fired. And this is why, a lot of what we're talking about today is going to hinge on this new law. You cannot be fired for a positive test of cannabis. However, like any other controlled substance or alcohol, your employer can prohibit you using drugs or alcohol at work, and you can prohibit you from being intoxicated while at work. So that's why this reasonable suspicion testing is so important, because employers that have reasonable suspicion of on-the-job use or impairment or intoxication can then go to the next step of using those traditional drug tests and physical evaluations to determine whether or not someone could be impaired. Additionally, similar to in the past, employers can always randomly screen current and prospective employees. And the one aspect that we're going to go over several times in this presentation is that CRC, the Cannabis Regulatory Commission, has in the law said, you're going to want to have a wire expert on site, which is a workplace impairment recognition expert. However, there is very little guidance on how you get to be that and what are the requirements to be that wire. Couple facts when it comes to marijuana. And again, this is dovetailing back to the criminal aspect. What should a police officer do if they smell marijuana coming from a vehicle during a motor vehicle stop? First, again, they're going to take the traditional investigatory steps that are necessary to determine if there's probable cause to believe the driver is operating the vehicle while under the influence, which violates NJSA 39-4-50. If so, then the driver can be arrested and the vehicle can be searched. So these are, search and seizure criminal rules that relate to marijuana. If the driver is not found to be under the influence, the odor of marijuana, either raw or burned, two distinct smells, by itself does not establish that reasonable suspicion to justify a continued stop, nor does it establish the necessary probable cause to conduct a search. In a marijuana possession case, or even a lower level 4th degree possession with intent to distribute case. So again, criminal or even municipal charges. As a result, the vehicle and the occupants, if you get to that prong where all you have is the smell, they have to be released and be free to go on their way after this, if they come to that conclusion. Fact number 2, what happens if someone is potentially under the influence and or in possession of marijuana at work? Obviously very different than, driving a car or being, at your house or something. The New Jersey employers, as we mentioned earlier, are not allowed to fire employees if they choose to consume marijuana or cannabis on their own recreational time. However, employees still can discipline employees that get high or use these substances during work hours. So despite all this, you still can say that in my place of business, you're not allowed to get high, just like you can't come to work and start drinking. Businesses also can do pre-employment drug screenings, post-accident drug screenings, reasonable suspicion testing, and random drug testing if they choose. But the most important aspect, and that's where Brian and I are working quite often on this, is having a legally compliant, robust policy in place so that it's kind of the playbook of how you follow that policy as far as your organization is concerned. New Jersey does allow the use of medical cannabis for qualified patients. That's been, long-standing in the state. And employers must respect the right of employees that choose to use marijuana as a treatment for conditions, again, such as for cancer, epilepsy, anxiety, and the like. However, despite this, this sort of exemption for people that choose to treat symptoms with medical marijuana, employers do not have to allow that individual that is considered possibly disabled to use the drug while at work, or allow that person to be impaired at work. And of course, remember everything, even with cannabis and recreational cannabis, everyone that uses it has to be 21 years or older, similar to alcohol. Just a little for going back for 1 second to the use of medical cannabis for qualified patients, just be also mindful of the fact that if someone is using medical cannabis for reasons such as, again, cancer, epilepsy, things like that, that you still have to be mindful of the fact that this person is likely disabled under the New Jersey law against discrimination and the ADA. And the piece of that would be, the next step would be, if considering this person is disabled, we might have to go into exploring potential reasonable accommodations and following that process to see if this individual that is disabled would need an exemption, let's say, from a policy that was put in place in your organization. And most importantly, as we saw post-COVID with the vaccine, when it comes to exploring reasonable accommodations, the process is critical in that it has to be, without getting too into it, interactive back and forth discussion where both parties come to a meeting of the mind that is suitable for the disability, but also does not cause the business an undue hardship. So make sure the policy is followed, as well as the process of that interactive back and forth discussion. So again, what Brian and I always say, critical to have policies in place that are good, robust, legally compliant, but those policies do have to be applied consistently and fairly to everyone. And you always have to be kept abreast of the constantly evolving federal and state laws that are always changing. So best practices for HR professionals and those in that field, compliance professionals, understand despite all of these laws, you do not have to permit marijuana use or cannabis use on the job, just like you wouldn't allow someone to come and start drinking, vodka at their desk. Very important, especially since we're waiting on the information on what a wire expert looks like. Make sure you're training managers to spot signs of impairment. We do provide that kind of training ourselves here, and that is, something that you can do in the meantime while we're getting further guidance from the CRC. Also think carefully about the type of test your company uses when it comes to drug tests, and stay on top of, new developments in testing. We always say with marijuana, different than alcohol, there's no breathalyzer, for example, that will, give you an exact figure out when someone's smoked or ingested marijuana and how much. Also very important to always talk to your attorneys about the relevant laws before setting policies and testing rules in place. Also, if you're operating in a different state, New Jersey plus another state, or New Jersey plus other states, remember that the laws might be very different as far as, cannabis and marijuana use, possession, et cetera, are concerned, because again, still on the federal level, it's not okay. And know that, again, the testing policies and procedures might have to vary by jurisdiction. And of course, always educate and inform your employees about the marijuana use policy and what would happen if they failed the test, they refused to test. What does random post-accident and reasonable suspicion testing look like at our place of business? So, you see some of these individuals. There's been a big debate on some of these companies, by the way, like Apple, Caesars Entertainment, and even Bravo. Some of these organizations, have debated whether or not you should continue to do, in light of these laws like New Jersey that said you can't refuse to hire or fire someone that has a positive test for marijuana or cannabis. So they're saying, should we continue to test? Now, Caesars, the vice president, said, we are not doing pre-employment screenings for marijuana because they feel they're losing too many otherwise qualified candidates, that when they see that and they give their consent, they pull their application. However, as you can see with Caesars, he said we are still screening, people for marijuana if we think they're under the influence or impaired at work, because obviously that's a concern. Additionally, with Bravo, they're saying that the piece that's interesting for them is that, it's different to cut out marijuana screening for someone that might work behind a computer at a desk versus someone that is using a knife or heavy machinery or working in a manufacturing facility, in that, obviously the stakes are much higher for injury, death, and dismemberment and the like if someone is impaired, operating a forklift or operating, on a factory line versus, sitting and typing at your computer. So, this is being debated, and, you want to just be mindful of what you think the best practice is for you and your organization. So a couple, the CRC, as we mentioned, is that agency that has aimed at helping employers address marijuana impairment in the workplace. And they are those enforcers, so to speak, that are charged with creating these standards, including what this workplace impairment recognition expert is and looks like. However, as I mentioned, the training that people can take right now are just, general training on, what are signs of impairment, what steps do we take if we reasonably believe someone's impaired. However, we don't have an exact roadmap for what a workplace impairment recognition expert looks like, or how you get certified to be that. So again, the current guidelines that we do have are that employers still can use established protocols and procedures when they suspect someone is impaired, and you cannot take adverse action against an employee unless there are observable signs of impairment and a positive test. So again, it's a two-prong requirement there. And as I keep mentioning, marijuana still remains illegal at the federal level, and New Jersey's marijuana laws do bar employers from taking that action based solely upon, if someone is using marijuana or cannabis when they're not at work and they're not impaired. So drug testing at work, like I mentioned, still can be done for other reasons, like post-accident, randoms, or if you think someone is under the influence or impaired at work. And, the rates for those categories haven't dropped as much, however, as far as we were discussing with Caesars and the like, as for pre-employment testing, which again, the jury's still out on that, so to speak. Some companies are saying, yeah, we still want to do pre-employment drug testing. Others are saying no, particularly when it's concerning marijuana and cannabis. And these reasonable suspicion tests that we did talk about do still include marijuana as one of the drugs that it's screened on the panel. But just note that the last thing you want to do is, first of all, not have a proper policy or procedure in place and test someone that you believe is high and have the test come back negative and end up with some sort of lawsuit due to the evolving law.
So as Nicole alluded to, in CREMA, there is a provision that sets forth that you shall not refuse to hire, employ, or discharge from employment, or take any adverse action, which could be demotion, it could be lessening their wages, solely because they use cannabis items. That would apply to whether they have a medical card or if they're doing it recreationally on their own. The best analogy I saw in some writings on this was that it's now, and this is from the CRC, to be treated as the use of alcohol. What you do on your own time is not necessarily impermissible, but nothing prohibits the employer from having a drug-free workplace. Nothing requires the employer to allow the use of cannabis in the workplace on or off hours, or obviously you can't come to work impaired, whether it's alcohol or on marijuana. The problem is that with alcohol, there's objective testing for that. A breathalyzer will give you the number, a blood test will give you the number right then and there, and if someone is impaired, and it also leaves your system relatively quickly. Cannabis has been known to stay in your system for 30 to 45 days. The question is, if someone's tested 30 days later, it was in their system, are they impaired? So we go to the next slide. This has been the subject of recent litigation that I'm going to talk about because there is a case of first impression in New Jersey, which is extremely important. But this is the part of the CREMA statute that employers all have to be mindful of. You can't take an action against someone solely due to the fact that they have cannabinoid metabolites in their system. That would be revealed from a blood test. Being a municipal attorney, I deal with police departments. They have threshold levels that set forth and establish certain guidelines as to what set of, for them, it's 15 nanograms per milliliter. But just because someone has that in their system, it's not enough to take an adverse employment action. There has to be something else. And as Nicole alluded to get to that test, you have to first observe, have reasonable suspicion and observe behavior. The CRC has recently issued guidance on workplace impairment. In September of 2022, they issued a 2-page analysis setting forth best practices. They also set forth a reasonable suspicion observed behavior report that should be completed by employers. And in there, it has all the states of impairment that you have observed. And they recommend that you have a supervisor and a second employee document that before you go for the drug test to get the confirmation. So if you have someone impaired at work, then and you have the confirmation through the drug testing because you have that reasonable suspicion filled out by the employer, then you would be fine within the confines of the law to take an adverse action. If someone is in a motor vehicle accident, the law allows you to take the drug testing as well. Another complicating factor is cannabis and marijuana is still a Schedule 1, Class 1 hallucinogen under federal law. It's still illegal under federal law. So if you have a CDL license, you operate heavy machinery or equipment, you have a federal grant, you have some type of federal program that would affect your employment, you're still permitted to engage in random drug testing, whatever it may be, so that you're not harmed from the federal aspect. So it's created quite a lot of issues for employers. Next slide. And that's kind of what I was just talking about in the next slide, that you can request the drug test based upon the reasonable suspicion that they were using it while engaged in the performance of employees' work responsibilities or any observable signs of intoxication. The issue that employers face is the Cannabis Regulatory Commission was charged with establishing guidelines and certifications for WIRES, Workplace Impairment Recognition Experts. This has not come out yet. So right now, employers are almost left to their own devices, and to have a supervisor fill out these forms, which show physical behavioral indicators of someone potentially being impaired. Next slide. So as I indicated before too, that drug test, you may still do random drug screening. You may do reasonable suspicion drug testing, but it has to be scientifically reliable, and unlike alcohol, where you have a breathalyzer, for testing for marijuana, it would usually be a blood test, it would be a urine test. Hair is another instance.
Hair is more reliable.
Right. So, but you, in and of that self, you need that physical evaluation to be done first. Next slide. And again, as I alluded to, that physical evaluation is to be done by someone who has the necessary certifications to set forth that impairment. It can be contracted with a third-party vendor. It can be a supervisor, employer who's trained with the certifications. But as of today, we don't have those credentials. Police departments have DREs, or drug recognition experts, that are trained in establishing impairment in the general public. Next slide. However, police departments are not allowed to use the DREs for their own police departments. They're required to use the WIRES as well, although that hasn't been established. When the law was created, they indicated that the CRC would work with the Police Training Commission.
Want to go back?
Would work with the Police Training Commission to establish those guidelines, because police officers have done that for years and years with DREs, or drug recognition experts. Next slide. So as I said, PREMA doesn't require the employer to repeal any rights as far as you're still allowed to have a drug and alcohol-free workplace. You don't have to accommodate the use of marijuana in your workplace, whether it's medicinal, recreational, at any time, on or off hours. Obviously, people can't be showing up to work impaired from alcohol. They can't be showing up from work impaired from marijuana. But the caveat is, as Nicole alluded to, which we'll get to the two cases I'll talk about, is there's still the law against discrimination out there if someone has a medical card and a disability for which they're treating and taking prescribed marijuana. Next one, yeah. So as I said, cannabis and the CRC has specifically set forth in their guidance that cannabis can remain in the body of this for a long period of time. And although tests are improving in accuracy, there is no perfect test right now. So that's why they say best practices is have documented observed behavior and physical signs of impairment, and then that would develop enough to establish reasonable suspicion testing. And then you utilize the drug test to verify that that person was under the influence. And if you have the physical observation, then you have the drug test that establishes that, then there wouldn't necessarily be any issues with taking an adverse employment action. We'll go to the next test. The Cannabis Regulatory Commission set forth other standard types of tests that you could utilize, including an ocular scan. One of the cases that recently came out of the federal courts is called Zanatic versus Walmart. Zanatic applied for a job in their loss prevention unit. He was provided with a job offer, but it was conditional on drug test. That drug test came back positive for marijuana. They rescinded the job offer. Zanatic filed a lawsuit on behalf of himself and all those similarly situated. So it was a class action suit in the state courts. It was removed to the federal courts, relying upon CREMA's provision that says you're not to take an action against an employee or refuse to hire someone solely because they take marijuana. CREMA has established that recreational marijuana is legal. The issue that the court was faced with was, in all the employment statutes or discrimination statutes, like the law against discrimination, like SEPA, which is the whistleblower statute, there are provisions in there for how you avail yourself of any rights. You go to court. There's damages you can seek if you were discriminated against, you were wrongfully terminated, there was a hostile work environment, you were a whistleblower and retaliated against. You can get back pay, you can get front pay, you can get punitive damages. There's fee shifting provisions, which if you prevail, you get your attorney's fees. CREMA has no such language in the statute, does not provide any remedy aside from that one statement that says you shall not take action against employers solely because they have cannabis in their system. And the court recognized that when you read CREMA, and it's very lengthy statute, most of it is focused on the regulations, the licensing of various facilities, which is another issue I deal with as municipal attorney, but they really didn't focus much on employment rights, and we're clear that it's not necessarily creating additional rights. But what the court said was that because there was no cause of action provision contained in CREMA, there was no remedy in CREMA, there was nothing in there about how someone could avail themselves of their rights by going to the courts, by going to the Division on Civil Rights, as to what damages or remedies they would seek. And because the CRC was established, which is the Cannabis Regulatory Commission, and they are charged with enforcement of CREMA, that based on the statutory language, that the CRC would be charged with enforcing someone's employment rights. Now, the CRC is really focused right now on the licensing, and I think September 27th is another deadline date for them with additional licensing. So the court, in a scathing opinion to the legislature, said the court recognizes that its decision leaves plaintiff, which was Zanatic, without a remedy and essentially renders the language of the employment provision meaningless. Yet that is the outcome dictated by the law. And mind you, courts will not rewrite legislation. That is not their function. It is not the function of the court to rewrite incomplete legislation or create remedies for a statutory violation where the legislature did not. If the state expects this statutory scheme to work and for these stated protections from adverse employment action not to be illusory, the legislature, the Cannabis Regulatory Commission, or the Supreme Court of New Jersey must act. If the legislature intended for there to be a private cause of action, it should amend the statute to clearly evidence that intent, including how the provision can be enforced, by whom, and what remedies are available, as it has previously done in many other employment-related statutes. If the legislature intended for the CRC to enforce the employment provision, then the CRC should duly adopt regulations to exercise that power and provide much-needed guidance to employers and employees. So at the federal court in the U.S. District Court of New Jersey, Walmart was successful in getting the case dismissed. It is now on appeal before the U.S. Court of Appeals in the Third Circuit. So there's more to be written on that story. And the court did drop a footnote and said that perhaps the New Jersey Supreme Court will weigh in on this because they can take questions, certified questions from the Third Circuit Court of Appeals and answer that question. But the court was very clear that they are not rewriting this legislation to put in manners and mechanisms to avail yourself of rights or remedies when it's not in the statute. So right now, what we're faced with is we have CREMA, which says you can't take an adverse employment action solely because someone takes cannabis. And that's still how all employers should be guided. But right now, the state of law is someone could not individually pursue that cause of action. It would have to be enforced by the Cannabis Regulatory Commission. But we do expect to hear more from the Third Circuit Court of Appeals in the next couple of months. Next slide. Just quickly, next slide. Just quickly, as I alluded to, being a municipal attorney, I've had to deal with police departments and have one of the first cases with a police officer who tested positive on a random drug screening shortly before the enactment of CREMA. Back in 2018, law enforcement agencies were required to implement random drug screening for all police officers. That has changed, and in 2023, the Attorney General issued guidelines based on CREMA, because cannabis is now legal, that you can no longer do random drug screening for cannabis of police officers. There has to be reasonable suspicion. Next slide. So that reasonable suspicion has to be either that there's reasonable suspicion that a police officer is using cannabis while engaged in the performance of their duties, or there were observable signs of impairment. And once again, that determination is made by the WIRE, the workplace workplace impairment recognition expert, not the DRE. If you go to next slide. When the policy was initially adopted, all kinds of drugs were required to be tested, including for random drug screening, some of which would be legal if you had a prescription and you disclosed it. Marijuana is no longer to be randomly screened of police officers unless there's some federal requirement or part of a federal task force, because again, that creates the complicating issue where cannabis is still illegal under federal law. Go to the next slide. As I mentioned at the very beginning, back in 2019, the J. Conant Compassionate Use Medical Cannabis Act came out and greatly expanded medicinal use in New Jersey from 2010, created the Cannabis Regulatory Commission. Slide. Similar to what we were talking about with CREMA, an employer can't take an adverse employment action, whether it's termination, demotion, etc., just because someone is registered and has a medicinal card. But the statute was clear too, and this is in the medical statute, that still doesn't restrict an employer from taking action against an employer if they're using it on premises, on or off hours. That you can still have a drug-free workplace, but employers need to be mindful when it's medical or medicinal, the law against discrimination. And the next slide. That leads me to the other case that I was going to briefly discuss that went up to the Supreme Court of New Jersey, Wild versus Carriage Funeral Homes. The plaintiff, Wild, was a funeral director who was driving the hearse and was involved in an auto accident. He was not at fault for the accident. The other driver apparently ran through a stop sign. When he was at the hospital, he disclosed to the physicians that he was a medicinal marijuana user. He had a medical card. He actually was treating it to alleviate the effects of cancer. The physicians at the hospital did not believe he was impaired in any way, shape, or form and did not perform any drug testing on him. It then got back to the employer that he was taking medical marijuana. There was a dispute as to whether he ever disclosed that to them before. However, their response was corporate couldn't deal with someone who was taking marijuana, and they terminated him. He filed a lawsuit under the law against discrimination, claiming that he had a disability, and if someone has a disability and you're aware of it, you have to engage in the interactive process and discuss what constitutes a reasonable accommodation. How could they have accommodate that use? This case went back and forth, and it went all the way up to the Supreme Court. And although it was based on a motion to dismiss before any discovery, he was allowed to pursue his claim. And the court had said it would be quite ironic if under the Compassionate Use Act, although that didn't create any additional rights, the employer could show such a lack of compassion to the employee here who was using marijuana permissibly. There was no evidence of impairment. And in this case, he could pursue his law against discrimination case under the LAD. What that leaves us with too is if someone has a medical card or is taking medical marijuana, they could certainly pursue a claim under the law against discrimination. If they are using cannabis on a recreational basis, right now the state of the law is they don't have an individual claim, but it still violates CREMA, and that we're waiting for guidance from the appellate division. So with that, I think we had a couple of questions, right? So
yeah. So just two examples. Let's say I applied for a job in New Jersey. I was required to do a post offer because I was divide, there's pre-conditional job offer and post-conditional job offer areas of inquiry, including testing that's permissible. Pre-offer, very limited. Post-offer, a lot more expansive. However, I do have a medical marijuana card for anxiety, and I'm able to use cannabis. So I do a drug test, post-offer drug test that's positive for THC. Again, the metabolite that gets people high. And I was not hired after my conditional job offer and after my drug test results were in. Do you think this is okay? And
no, because that seems to follow lines of the wild case we talked about with the funeral home, wherein this individual did have a medical marijuana card. Now, under the medical component of the statute, if a test does come back positive, they have 3 days to establish or provide information that they have a medical use or basis, and then they should engage in the interactive process and discuss it can be accommodated. So I think that's going to be a problem for the employer, because even Walmart, in their case, it was recreational and that violated CREMA, but right now the court said there's no cause of action. So that would be a problem. So.
All right. And the second one, I work as a clerk at the supermarket. I slipped and fell at work and was drug tested as a part of the post-accident drug testing policy. I tested positive for THC and thereafter fired. I did smoke marijuana or cannabis over the weekend. What do you think? That
goes to the bases for, it's not just the fact that it was in their system. It was the fact that there was you're permitted to do that post-accident. So there's an explanation as to why they had an accident. And I think the employer in that instance would be well within their rights to terminate the employee. And so another question that comes up quite a bit is, what about during the job interview? Can the employer ask questions about your use of cannabis?
I always say there's no per se prohibition. However, we would definitely caution that line of inquiry in light of the various laws that we discussed today. First of all, you might get into, what if it comes back positive? Well, if they say, yeah, I smoked, like, you can't really do much with that, similar to a test, like it's kind of irrelevant. Additionally, what if additional information comes out, like, oh yeah, I do use marijuana because I have anxiety or something like that. And then you're creeping into potential if you don't hire that person, you're creeping into disability discrimination potential claims under the New Jersey law against discrimination. So again, we would caution against it. And also keeping in mind too, if you're a business though, however, that deals with federal contracts or federal grants or something like that, then that might be a little bit of a different story, in that I think it is more relevant and you'd probably be safer asking about someone's marijuana or cannabis use at a job interview, because if they say yes, then that could, just because of the federal aspect, that can make them not be a viable candidate.
And what about drug tests prior to hiring?
Similar to what I said, I think you could probably do it, but what's the point if it comes back with, cannabinoid metabolites in it? So I think you there's no prohibition. However, again, first of all, you're going to want to have a policy in place, regardless, and whether or not you do and get consent to test someone. But the results are, unless you're dealing with a federal contract, the results are going to be pretty much meaningless if all that comes back is that they, have a positive result for marijuana or cannabis.
And what about an employee who gets high during their break? How do you deal with that employee?
Yeah, that I would also say you're going to want to have a policy. You still can prohibit, as we said, use of marijuana or any substance on work premises. Now, the next question is, what if they went out to their car or walked down the street to the park, or were working, ran home and smoked during their break? But again, just making sure that they're not coming back to work impaired. That's one line of inquiry. And secondly, another line of inquiry is whether or not they might be disabled and be using that marijuana for a medical reason. And thirdly, though, if it's being done, I think it's clear, if it's being done at work on the property, even if the person, I think, is on break, you still probably can prohibit it as long as you have a policy that you're consistently applying.
And lastly, for the employee who gets high off hours.
Again, if you get high off hours, the best way to deal with that is, if they get high off hours and they're not seemingly impaired at work and they're not, smoking on the job or anything like that, I think the only way that you can probably take an adverse action is if you have those two individuals that are trained, making contemporaneous observations of that they reasonably suspect that the person's impaired, and you send them for drug testing. But just the fact that someone uses marijuana or cannabis, during the weekend or when they're not working, I think in and of itself is not a reason to fire or suspend or something like that. So
with that, do we have questions?
No, I'm sure. No, I'm just kidding.
Yeah, this is a hot topic, and I want to thank you so much for a very informative presentation. We do have a couple, I think we have a couple minutes. One that come up a couple times is, where can a company go to get trained to detect reasonable suspicion? And does the state of New Jersey require some sort of certification?
The CRC hasn't issued the certification guidelines just yet, but the Cannabis Regulatory Commission at this point has issued the guidance, and it's on their website. And there's also the Reasonable Suspicion Observed Behavior Report. It's a 2-page report that's to be filled out. Right now, it's almost left to have a manager or supervisor, but there's really no guidelines right now for training, which is why we say at least the employer's in a tough spot.
But I have trained, I work with a lot of transportation individuals, both ones that are federally regulated and not. And that's where I said the best practice would be to bring, our firm, Brian and I, are able to do this, taking into consideration the laws, these documents and forms that are available to us, and simply train people on, how to detect reasonable suspicion. What do you do if someone, for example, you call them into a room after the observations and they run, which has happened actually to a client of mine, where they bolted out of the office. Like, what do you do in that case? And how do you handle refusals? How do you handle delays? So that's why we can provide that training at this point in time based on what information we have. So, and our contact information is on the screen.
Thank you. Yes, the refusal has come up a few times. Another one was, what do you suggest the next step if an employee refuses to go for a drug test after being confronted, after there's reasonable suspicion and documented reasonable suspicion?
And that's how, when I do the training, I say, if you want to have a policy in place and you want to delineate in that policy that a refusal is considered a positive result. And taking it a step further, if someone refuses and then bolts out of the room, obviously that's going to be considered a positive result as well. But then I would, in the interest of the safety of the individuals, the public and other people, would alert the police with descriptions of the individual, what they're wearing, the car they're driving, any of that you could alert law enforcement about. Do you have anything to add?
No, but I would clearly delineate, set that forth in the policy that would allow you to then take immediate adverse action, terminate them for violating your policy, which you're allowed to have.
Because at that point, if they refuse and a refusal is considered a positive test, you have the observations and the documented observations. And then at that point, you have the positive test based on their refusal. Again, written in policy.
Yeah, thank you so much. I think we have, and you kind of got over this, but since marijuana stays in your system longer, can a positive cannabis result be used in a post-accident or reasonable suspicion testing?
Wait, say that
Since
So
it
if
remains, it's not like alcohol. So
right,
that's the challenge we're all faced with, because it still stays in your system for 30 days.
Yeah.
So the question is it enough for post accident testing, which a lot of insurance companies are going to require if someone's in an accident? I would say yes.
I think so too, but just straight up the other scenario I think you described, I think it's not enough, right? If it's just a pre-employment or something, as we mentioned.
No, but post accident.
Post-accident, yes.
Yes.
And that's still, as we mentioned, you still have the right to test people post-accident.
And that goes hand in hand with the impairment. So if someone's in post accident, you can do, and then you could say that was the cause. And I know a lot of carriers are requiring it. So.
Yes. And back to the hair follicle, just for a bit of information, that's really as of now, I'm not super familiar with the ocular scan, that's new, but the hair follicle test, which is very expensive and something that's more used in criminal and family court, like when you're dealing with DCP and P cases and things like that. That's where they take, pieces of someone's hair and they're able to detect how much they smoked, when they smoked, and things like that. Was it yesterday? Was it an hour ago? Was it 30 days ago? And that's just, I think, something that employers, it's just too expensive and too much of a process, because it's not automatic to implement, on a basis, but almost possibly a daily basis versus, a blood test or a urine test or something like that.
Well, thank you so much. That's about all the time we have for questions. Unless Brian or Nicole, do you have any last words or thoughts?
I mean, I think the best practice is, as Nicole said, make sure you have a written policy, but know the law is constantly evolving and changing. So you just have to stay on top of it. But it's always best to have a very specific policy, and remember that you're still allowed to have a drug-free workplace.
Yeah, and that's why I was gonna say have a policy, but make sure it's also implemented in a consistent way, that managers are not picking and choosing who's subject to the policy. And I also, to just simplify a little bit, I tell people, even though this is a hot topic with marijuana and cannabis, if someone's impaired at work, I keep going back to it. I don't care if they're on, heroin or rum or, Benadryl and vodka, whatever it is, you still are allowed to have that drug-free workplace, and you still can prohibit people from being impaired on any substance, legal or not, in the workplace.
Well, thank you so much. And don't forget that everyone will be receiving a recording of today's webinar via email. A few people asked about that, so you can go back and pause on slides and things that you would like. Just a little promo. Our next webinar is Embracing the Future of HR, Exploring AI's Transformative Power, which will take place Tuesday, September 19th, 1 through 2 p.m. So by all means, feel free to register for that. You can visit us at our website at njbia.org/webinars. So until next time, for Brian and Nicole, we can't thank you enough. I mean, this is a topic that people are very interested in. I'm Casey Skarecki, and I want to thank you all for being with us today. Have a fabulous rest of the day, and cheers. Thank you so much.
Thank you for having us, and thank you for attending, everyone.
Till next time.
Thank you.
Bye-bye.
Bye.